Good afternoon. My name is Kim Stanger. On behalf of myself and my colleagues Pia Dean and Teresa Locke, we'd like to welcome you to our webinar today dealing with the new ACA non-discrimination rules. We've got a lot of stuff to cover today, and so we may actually go over a little bit beyond our normal 1 hour today. As far as preliminary matters, you should have received links that will take you to our written materials, including copies of our PowerPoint. We've given you a copy of the new non-discrimination rules, which are found at 45 CFR Part 92. They're actually found at the back of the HHS commentary that we provided. That HHS commentary goes along with the rules and explains how the rules are intended to operate and the like. That is found at 81 Federal Register 31376. Again, the actual regulations themselves are at the back of that. We've also provided you with some sample documents that HHS has provided, including a notice of non-discrimination, a statement of non-discrimination, and taglines, which hopefully will make sense by the end of this program, along with a couple of fact sheets. Although we didn't provide these to you, at least in written form, we have posted 3 client alerts on various aspects of this new ACA non-discrimination rules that are available at our website. This presentation is being recorded, and should you have nothing better to do over the weekend and want to listen to it again, you can download that for free at our website. If you have questions during the program, please feel free to submit that to us. You can either use the chat line on this program, or you can email any of us, any of the presenters today, at the links that are up there on your website. So with that said, let's get started. A little bit of background on this thing. This is the overview of what we want to talk about today. We'll give you a little bit of background. We'll talk about the new rules and what they require, including their application, to whom they apply, the new notice and tagline requirements, which are maybe the most significant changes in the rules, the requirements for certain entities, and then Pia and Teresa specifically will talk about application to specific types of classes of individuals. And then Teresa will talk about enforcement and wrap up with some action items that you may have. A little bit of overview and background on this. We are going to focus today on the non-discrimination rules as they apply to healthcare providers. We are not going to get into the health plan stuff, since most of the participants on these programs are typically healthcare providers. We decided to focus on that. So if you are a health plan, just realize that there are some additional requirements that apply to you that we're not going to cover. In addition, it's very important to understand that the new ACA discrimination rules don't take away or undermine any other existing discrimination laws that are out there, either at the federal level or at the state level. So you still have to comply with those other federal and state discrimination statutes that are there. Think of it this way. The new ACA discrimination statutes basically just build on the existing rules that are out there and extended it in the context of the healthcare, for healthcare providers, in the context of providing items or services in healthcare programs. That's essentially what the Affordable Care Act did. We had this kind of patchwork of discrimination laws that were out there, but very few of them applied specifically to the healthcare context. They would affect healthcare providers. You've been dealing with things like limited English proficiency situations, persons with developmental persons with disabilities for quite some time. As part of the Affordable Care Act, they kind of took all of those in and they applied those in the healthcare context. So under Section 1557 of the Affordable Care Act, it states that an individual shall not, on the basis of race, color, national origin, sex, age, or disability, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any health program or activity, any part of which is receiving federal financial assistance. Well, we've had that rule for several years now, but we did not have the implementing regulations. As I think Teresa will talk about, the OCR has actually been enforced in the statute, even though we didn't have the regulations. But now we have the regulations. The proposed rules were published on September 8th, followed by the final rules, which were published on May 18th, 2016, just a little under a month ago, which, for you trivia buffs, is also the date that Mount St. Helens erupted. The final rules take effect 60 days thereafter, which is July 18th, 2017. 2016, so you have to comply by then with most of the requirements, except the notice and tagline rules. You've got to put those in place 90 days after the effective date, so you have to have those in place, if I counted correctly, by October 16th, 2016. Essentially, these non-discrimination rules prohibit discrimination on the basis of race, color, national origin, sex, age, or disability. Now, these rules, as I mentioned, do not preempt or replace other discrimination laws. So to the extent that you are subject to those other laws, you still have to comply with the other laws. In addition, when these rules were published, there was a lot of commentary. A lot of people wanted religious exemptions, but HHS did not actually incorporate a religious exemption. In fact, it kind of split the difference. It did not include a religious exemption, but on the other hand, it does not replace other protections for religious freedom or conscience that may be out there. So, for example, if you have a state freedom of conscience law, you can still apply that in the context of these new rules. If there is a federal or state law dealing with religious freedom, then you can still presumably get the benefit of that other law, including the Federal Religious Freedom Restoration Act, certain provisions under the ACA, and the like. Those protections, to the extent there's this other law that gives you protections, then you're entitled to those protections under the non-discrimination rules. Well, who does it apply to? These new non-discrimination rules apply to any entity that receives federal financial assistance from HHS. If you've listened to my conferences in the past, you realize that anytime you agree to accept federal money, there are always strings attached. Some of those strings are these new non-discrimination rules. So any entity that receives federal financial assistance from HHS has to comply with these new non-discrimination rules. Federal financial assistance is construed pretty broadly. It includes Medicare Parts A, C, and D. So if you're a participating provider in Parts A, C, and D, then you're going to have to comply. If you participate in Medicaid or get Medicaid money, if you get grants, loans, subsidies, etc., then you are sucked into the scope of these new non-discrimination rules. Interestingly enough, it does not apply to Medicare Part B. So if you receive no other funds except Medicare Part B, then theoretically you don't have to comply with the new ACA non-discrimination rules, but chances are you're going to have to comply with other statutes, including your state non-discrimination statutes. So the new rule is going to apply to virtually all hospitals, nursing facilities, clinics, medical practices, solo group practices or solo physician practices, individual physicians, any of those entities who participate in Medicare Parts A, C, and D or otherwise receive federal financial assistance. Well, what are the requirements? Well, the requirements are basically summarized here. Generally, applicants for these federal programs participate. In the future, you're going to have to sign a form whereby you promise to comply with these new rules. In addition, if you are a covered entity with 15 or more employees, then you have to do a couple of things. You've got to appoint a compliance coordinator to make sure that you're complying with these rules, and you have to establish a written grievance procedure. We'll talk about those in a minute. In addition, you're going to have to post certain notices of non-discrimination and include taglines along with those notices and statements of non-discrimination on significant documents and in certain other locations. And you're going to have to, despite doing all of that, you need to continue to not discriminate on the basis of race, color, national origin, sex, age, or disability, including you're going to have to treat men and women equally in the health care they receive and treat individuals consistent with their gender identity. PA will talk more about that. You're going to have to provide language assistance, which generally means interpreters and translators to persons with limited English proficiency. PA will talk about that. You're going to have to provide auxiliary aids to those with disabilities and make newly constructed or altered facilities accessible to those with disabilities. Teresa will talk about those items. So let's go through and talk about at least the first ones, the first items. As far as this, for those who want to participate in these federal programs as part of your application process or when you sign up to participate, you're going to have to sign a document in which you assure that your program, your provision of health care, will be operated in compliance with the rules. It'll be similar to what you have to sign already under Section 504 of the Rehabilitation Act and certain other obligations. Just watch for that. We will see that start coming down the pipe now that we've got the new regulations. If you are a covered entity with 15 or more employees, you have to designate at least one employee to coordinate your compliance with these new rules. Among other things, that compliance coordinator is in charge of investigating any grievances that may come up. This requirement is new for most healthcare providers, except to the extent that you're covered under Section 504 of the Rehabilitation Act. It basically parrots the requirements there. They're pretty broad in giving you direction on what you need to do here. They just tell you that you got to appoint that compliance coordinator. You may use the same person designated under other discrimination statutes, your compliance officer, your office manager who seems to do everything. You can appoint a person specific to these issues. They don't really tell you how. You just have to have a person that is responsible for compliance with these new ACA discrimination rules. In addition, if you're a covered entity with more than 15 or more employees, you're going to have to adopt a written grievance procedure. Again, the government is pretty broad and doesn't give you many specific requirements for that grievance procedure, other than to say that you must incorporate due process standards, meaning that you give the person who has a grievance, the complainant, a chance to be heard and a fair-minded consideration. And it's got to provide for the prompt and equitable resolution of grievances. Now, you may structure that within the bounds of those broad parameters pretty much any way you want to. You could use the same grievance process that you established under other laws. You may modify or come up with your own grievance standards. The government has provided us with a sample grievance procedure. It's attached as Appendix C to the regulations and the documents that we provided to you. Under the HH sample grievance procedure, which you are not required to use. You can have a different process so long as you provide the due process and a prompt resolution. But under the written sample that the government's given you, the complainant may file a written grievance within 60 days. That written grievance could include, you can require them to include their name, address, identify what the problem is, and the requested remedy. Once they submit it, the compliance coordinator must conduct through a thorough investigation within 30 days and report back to the complainant. In the process of doing that investigation, you need to make sure that it's thorough. You need to do your best to maintain confidentiality and maintain appropriate documentation to show that you complied with that investigation. After that 30 days, after you notify the complainant may then have a process to appeal beyond the investigator up to the administrator or CEO or board within 15 days. The administrator, CEO, or board must then consider that appeal and issue a written decision within 30 days. You may not retaliate against the complainant for their complaint, and you've got to provide language assistance or auxiliary aids to help out with that grievance procedure. This, again, is just a sample that the government's come up with. You're not required to comply with this. If you want to, however, you can tweak it as you want. You just need to make sure that you satisfy those general rules that you're providing due process and an appropriate and prompt response to any grievances. Now, there is a general principle that sometimes the regulations will require a complainant to exhaust their administrative remedies before they can complain to the OCR. That is not the case here. A complainant can go directly to the OCR, the Office for Civil Rights, for a complaint of a violation of non-discrimination rules instead of or in addition to going through this grievance procedure. So they are not required to go through this grievance procedure before going directly to the Office for Civil Rights, and Teresa will talk more about that later. All right, let's talk about the notice requirements. I think for most of you, this is going to be the most significant change in operating your program, because you're going to have to come up with a new notice of non-discrimination that you're going to have to publish or post in physical locations, on your website, and in certain documents like we'll talk about in a minute. There's different types of notices that you have to give. The first is you have to provide a notice of non-discrimination. This applies to all covered entities, not just those with more than 15 employees. It's all covered entities. You've got to post a notice. That notice has to state that the covered entity does not discriminate based on race, color, national origin, sex, age, or disability, that the covered entity provides auxiliary aids to persons with disabilities free of charge and in a timely manner, that the covered entity provides language assistance, for example, interpreters and translators, free of charge and in a timely manner, how that person can obtain those aids and services, contact information for the compliance coordinator so that they can contact that compliance coordinator if they have a problem or need some questions answered, how they can file a grievance, and how to file a complaint with the Office for Civil Rights. In order to help you, because the government is so helpful, they have published a sample notice that is available at that website or as Appendix A in the materials that we have provided to you. You are not required to use the sample notice that the government has given to you, but, you know, you've got the stamp of approval if you do use that sample notice that they provided to you. Now, for this notice of non-discrimination, you're only required to post that notice in English. You're not required necessarily, at least by these regulations, to post it in multiple different languages as opposed to the taglines. Now, HHS encourages you to post the notice of non-discrimination in one or more of the most prevalent non-English languages frequently encountered by you in your geographic service area, but at least under these regulations, you're not required to. But of course, you still have the general requirement that you've got to provide appropriate language assistance services for LEP persons, so to the extent that you would be obligated to provide this type of information or to a person who speaks with limited English proficiency, then you still may have to provide a translation or an interpreter in order to ensure that they're aware of their rights. And you are going to have to post certain taglines in non-English. Let's talk about those taglines. Taglines are short statements written in non-English informing the person that the language assistance services are available free of charge. So for this notice of non-discrimination, it's got to contain those 7 elements, and that can be in English. They encourage you to do it in non-English, but you're not required to, at least under the express regulations. But these taglines, you do have to post in non-English. Those taglines basically just tell the person that, hey, if you speak whatever language it might be, the language assistance services are available free of charge, and you can access those by calling a particular number. You have to provide that translation in the different languages. Now, which languages do you have to do? Well, it depends. You have to post that language in, post that tagline in languages spoken by persons with limited English proficiency in the relevant state or states. You have to post that tagline in the top 15 languages from your relevant state. You've got to post that tagline in physical locations that are available to the public or where you interact with the public. You've also got to post that tagline in those 15 languages on your website, and you've got to post that language or include those taglines in significant communications and publications. We'll talk about those in a minute. In addition, you've got to post those taglines in the top 2 languages in your relevant state or states in small-sized publications. Now, I'll talk a little bit more about that in just a minute. Now, when it comes to posting those taglines, you've got to post those in either the top 15 languages in your state, most prevalent languages in your state or states, or the 2, depending on where you're posting it. You've got to post the taglines in the top 15 languages in your physical locations, on your website, and in your significant publications. For small publications, you only have to post the taglines in the 2 most prevalent languages. Now, that depends upon the languages that are prevalent in your state, or if you operate in multi-states, then you can aggregate all of those states to come up with the top 15 languages. So in that way, if you operate in multiple states, you don't have to come up with different taglines, different notices for each of your different states. You can use the same tagline, the same notice for wherever you provide those services in multi-states. You can aggregate the states. You're not required to, but you can if you want. Now, even though you post these taglines informing the person that, hey, these language assistance services are available to you free of charge, that does not necessarily resolve your obligations to otherwise take reasonable steps to provide meaningful access to persons with limited English proficiency if it's reasonable to do so under the principles that T is going to talk about with a few minutes. So you've got to post these taglines. That doesn't necessarily take care of all of your issues when it comes to dealing with limited English proficient persons. but it's you've got to satisfy at least that requirement. Okay, so where do you have to post those requirements, that notice of non-discrimination and those taglines? Well, by October 16th, all covered entities must post that notice of non-discrimination and taglines in the top 15 languages in conspicuously visible font size at the following locations. First, you've got to post them in a conspicuous physical locations where you interact with the public. So you've got to physically post those along with your notice of privacy practices and other things that you've got to post in your waiting rooms and other facilities, physical facilities. In addition, you've got to post that notice of non-discrimination along with the taglines on your website in a conspicuously accessible manner that's accessible from the home page. So you don't necessarily need to post that notice and all of the 15 taglines on your home page. You can contain links to other pages as long as those links are prominent on your home page and they include in-language links from the home page. So you can't just have it in English that other people can't see. You would have to post those in-language links from the home page. In addition to posting that in physical locations and on your website, this is the one that I think is maybe the most problematic. You've got to post those notice and taglines in significant publications and communications to the public and patients. Well, what does that mean? Well, that means you've got to post them in your significant documents that you're providing. Well, what does significant mean? What documents are we talking about? Well, the government hasn't given us a whole lot of guidance on this. They have told us that they're going to interpret significant, it's going to be interpreted broadly. It would include things like outreach documents, education and marketing documents, patient handbooks, notices requiring a response from the patient, presumably your, for example, your HIPAA notices, written notices regarding rights and benefits, presumably consent forms, complaint forms, those types of things. But they don't give us a whole lot more guidance. So I would encourage you to go back and read from 81 FR 31401-02, which is in the materials that we've given you. They basically tell you kind of that stuff. We're going to have to watch and see if we get more guidance from the government concerning what documents we're going to have to modify in order to provide these additional notices. Now, you only have to provide that long notice of non-discrimination with those 7 elements, plus the taglines in 15 languages in your larger documents. You don't have to include those in small-sized publications like postcards, pamphlets, and trifolds. I'll talk more about that in just a minute. Now, the government said you've got discretion in how you post it. You've got to post it, but you've got discretion in how you post those taglines so long as you satisfy the regulatory standards. For example, you could combine them with other notices that you have to give otherwise. You may include those notices at the beginning of the significant documents. You may instead have a separate notice that you just hand out with those other significant communications that includes this notice. You may include on a separate web page, again, as long as you've got in-language links that takes the patient to that web page. Ultimately, the test is going to be whether the content is sufficiently conspicuous and visible that individuals seeking the services could reasonably be expected to see and be able to read the information. You got to make sure that the information is communicated. You've got flexibility in how you do that as long as you make sure the information is communicated in that manner. Now, that's for the larger documents. Well, what about small-sized publications? Well, for small-sized publications, you got to publish 2 things. You got to include 2 items. By October 16, 2016, for small-sized publications, you've got to publish the following in conspicuously visible font size. First, a statement of non-discrimination. You don't have to publish that whole notice of non-discrimination. You only have to post a statement of non-discrimination. The government has given us a sample. The sample is that covered entity does not discriminate on the basis of race, color, national origin, sex, age, or disability in its health programs and activities. In addition to that statement of non-discrimination, you've also got to post taglines in the top 2 languages spoken by the LE persons in the relevant states, which are presumably going to be Spanish and some other language. That tagline, again, would say in that other language, attention, if you speak, insert whatever the language, Espanol, language assistance services free of charge are available to you by calling this particular number. So for larger documents, you got to post the notice and the taglines in 15 languages. For small-sized publications, you've just got to post the statement of non-discrimination plus the taglines in 2 languages. The government has given you fairly significant resources to help you do this, including sample notices that have been translated into different languages, including all of these different languages that are there on your screen. All right, that is a brief overview of the new notice requirements that you're going to have to comply with by October 16th. I'll turn the time now over to Pia, who's going to talk about the specific rules dealing with sex discrimination.
Thank you. Thanks, Kim. I appreciate it. Hello, everyone. As Kim said, I'm Pia Dean, and I get the chance to talk to you about discrimination based on sex and limited English proficiency. I'd like to start with sex discrimination. The issue of discrimination based on sex is particularly interesting because, in my opinion, this is where the new regulations most advance current law. While our laws on sex discrimination currently being enforced are based in large part on case law, this is the first federal law to codify discrimination based on sex. So I'm turning to page 24, and you'll see there that Section 1557 of the ACA is the first federal civil rights law to prohibit discrimination on the basis of sex. That's the way that they've worded it. Remember, just like Kim said, this does not preempt or alter other laws, and providers must continue to comply with other state and federal laws in addition to the new ACA discrimination rules. Like Kim said, the new regulations do not add to the conscience or religious freedom laws, but it also doesn't change them anyway. So those religious freedom and conscience laws remain in effect, in full force in effect, and I think that they're particularly important here in terms of the sex discrimination because there is some advancement in the law in the way we're thinking about sex discrimination. Broadly speaking, slide 25, the new rules specifically prohibit discrimination based on an individual's sex, basically whether they're male or female, pregnancy, childbirth, or related medical conditions, 3, gender identity, and 4, what the new regulations refer to as sex stereotyping. We're going to get into that in some detail. Going to the next slide. What does this new non-discrimination on the basis of sex mean? Well, number 1, women must be treated equally with men in the health care they receive and the insurance they obtain. So neither providers nor insurers can discriminate on the basis of a person's sex. Number 2, individuals cannot be denied health care or health coverage based on their sex, including their gender identity and sex stereotyping. Number 3, a covered entity may not, in providing or administering health-related insurance or other health-related coverage, deny, cancel, limit, or refuse to issue or renew a health-related insurance policy or other health-related coverage or impose additional cost-sharing or other limitations or restrictions on the basis of sex. So no matter whether you're dealing with male, female, or transgender, the way that the health program is administered and the way coverage or health care is provided cannot be dependent on any of those factors in either the cost or the way that a person is accepted for care. Number 4, categorical coverage, exclusions, or limitations for all health care services related to gender transition are discriminatory. I want to say that again because it's a very important distinction. This is the first regulation that I know of that has come out specifically and said that any coverage exclusions or limitations based on gender transition are patently discriminatory. So I think that's a significant change. And while it comports with case law that has been around since the late 1980s, it is the first time we've had a regulation that specifically addresses that. Number 5, individuals must be treated consistent with their gender identity, including access to facilities. 6, providers may not deny or limit treatment for any health services that are ordinarily or exclusively available to individuals of one gender based on the fact that a person seeking such services identifies as belonging to another gender. This means that the health services sought, well, let me back up. This means that no matter how a person identifies themselves, we cannot deny or limit treatment. I do want to point out that this does not mean that it goes across the board in terms of medical appropriateness. The medical services must be medically appropriate. And in other words, this means that the new rules do not require a covered entity to provide a prostate exam to a person who does not have a prostate, or a cervical exam for someone who does not have a cervix. So it still must be medically appropriate, but in all other areas, it cannot be limited on the basis of how a person identifies their gender. 7, sex-specific health programs or activities are permissible only if the entity can demonstrate an exceedingly persuasive justification. That is, that the sex-specific health program or activity is substantially related to the achievement of an important health-related or scientific objective. I want to point out that the language exceedingly persuasive is the language used in the Federal Register. So this is OCR's language to say that they're going to look at these types of sex-specific health programs or activities particularly closely and rigorously to make sure that there is a important health-related or scientific objective. Examples would include research that requires either 2 X chromosomes or an X and a Y chromosome. And beware, as I pointed out here, that OCR will evaluate these very strenuously. So I would urge all of you to understand that only those programs that have a legitimate reason for excluding an individual on the basis of sex will likely pass muster from the OCR. 8, the final rule does not resolve whether discrimination on the basis of an individual's sexual orientation status alone is a form of sex discrimination. And I've given you the specific site. There's been a lot of discussion about this law or this set of regulations extending gender identity and transgender individual rights, and whether it had the same effect on sexual orientation. The rule specifically says that they are not resolving discrimination on the basis of a individual's sexual orientation, but it goes on to say that it will evaluate complaints that allege sex discrimination rated on an individual's sexual orientation to determine if they involve the sorts of sex stereotyping that can be addressed under the new discrimination rules. And I think very importantly, that they anticipate that the laws in this area around sexual orientation will continue to evolve, and that it will enforce Section 1557 in light of these developments. So if we see the continued progression that we have over the past 5 years in sexual orientation, I think OCR is signaling that they will continue to keep pace with that, and they'll consider issuing further guidance on this issue as appropriate. So I want to break these down into 2 areas that I think are particularly important. The first is pregnancy, and I'm on slide 30 for those of you who are looking at the slides. The law prohibits discrimination on the basis of pregnancy, childbirth, false pregnancy, termination of pregnancy or recovery therefrom, childbirth or related medical conditions. Okay, again, nothing replaces or displaces the existing protections afforded under the RFRA Act or under other conscience laws. But this does specifically say that we're going to not allow discrimination on the basis of pregnancy, childbirth, false pregnancy, termination, childbirth, or other related conditions. This is not new regulation. These regulations exist in other places, but this is the first time it's been labeled under discrimination on the basis of sex. I also want to point out that later in this presentation, I'm going to give you some examples of OCR actions, and I was not able to find any OCR action on the basis of discrimination based on pregnancy in the last couple of years. So I think the law is fairly well settled on this and that we know what they are. Most of the challenges now related to pregnancy come from the Religious Freedom Act or other conscience laws. So let's go to gender identity. And I liked this graphic on this particular slide because I think it demonstrates where OCR has gone with this rule. We used to just think of gender as male and female, and now we are expanding that to a much larger set of ideas. The final rules define gender identity as an individual's internal sense of gender, which may be male, female, neither, or a combination of male and female, and which may be different from the individual's sex assigned at birth. I thought this was an interesting expansion. Again, this is based on a federal case known as Price-Waterhouse versus Hopkins that was decided many, many years ago. And so this is not a new concept, but it is the first time that we put it into regulations. And what I thought was most interesting about it is that it seems to go beyond just the idea of male, female, or transgender, but also to this idea that people may identify as being of neither sex or of both sexes at the same time. A transgendered individual is an individual whose gender identity is different from the sex assigned to that person at birth. The new rules prohibit discrimination on the basis of sex stereotyping, which is defined as stereotypical notions of masculinity and femininity, including expectations of how individuals represent or communicate their gender to others, such as behavior, clothing, hairstyles, activities, voice, mannerisms, and body characteristics. So any of those factors are considered stereotyping. The final rule adds an additional reference that was not found in the proposed rule that clarifies that sex stereotypes include gender expectations related to the appropriate role of a certain sex. So to the extent that a clinic or a provider, a covered entity of any kind, takes on a practice or a protocol that is based on gender expectations, those are discriminatory. OCR adopts the position that sex stereotypes encompass not only stereotypes concerning the biological differences between the sexes, but also includes stereotypes concerning gender norms. So if the practice is based on how a woman would typically act or a male would typically act or behave or dress, those are discriminatory under the new ACA rules. Sex stereotypes, I've given you a quote here, sex stereotypes can also include a belief that gender can only be binary, and thus individuals cannot have a gender identity other than male or female. The gender identity spectrum includes an array of possible gender identities between or beyond male and female. I think that's a really important point. I've received the question, are forms that now say male or female and have two boxes to check, are those discriminatory? And I believe, looking at these regulations, that that is likely the case. It may be that all that is necessary is male, female, or other and identify, or that you can go beyond that and say male, female, both, neither, transgender. But we're now moved beyond in the regulations this idea that gender identity is binary, or that there's only two ways to think about sexual orientation. So how does this play out? How does this work? Well, starting on page 33, I've given you some examples of recent OCR enforcement efforts under this particular section. As Kim mentioned, that we've had enforcement under Section 1557 for some time now. We've just now gotten around to codifying the regulations. But since we have prior activities by OCR, we've had a chance to take a look at what their enforcement efforts are, and I think that they're very illustrative of what we're going to see in the future. So I've given you some examples. The first is a hospital policy that automatically assigned a male spouse as a guarantor, solely responsible for the patient, when a female spouse received medical services. But when the male spouse received medical services, the female spouse would not automatically be assigned as guarantor. So in other words, men were treated differently than women. This happened at both the St. Bernard Medical Center in Arkansas and the Avera Marshall Regional Medical Center in Minnesota. So we've seen a couple of examples of this in the last couple of years. The second example is a complaint that came out of Louisiana at the Turo Infirmary Emergency Department in Louisiana. It was a complaint from a male victim of domestic abuse that he was subjected to rude comments by hospital staff because he was the male and he was the subject of the sexual or of the domestic violence. There, they agreed to revise their abuse protocol and train the staff on identifying and assisting abuse victims. By the way, in almost every example I'm giving you here, there was a complaint, OCR investigated, and there was an agreement of how it would be handled. These were not ones in which penalties were assessed, but rather where protocols and practices were changed because of the OCR investigation. The third example is, I think, a particularly interesting one. It happened here in Colorado, and it was the Colorado Women's Wellness Connection Program, which is a well-known program here, that denied a transgender individual mammograms because she transitioned from male to female rather than male to male. Rather than, that should be female to male. I apologize for that. The policy was based on the CDC's guidelines, and the CDC had basically come out and said that where you have a transition from male to female rather than female to male, you do not have to do mammograms. And the transgendered individual brought up a very good point, which was that because of the hormones that she was taking to maintain her feminine identity, she was more at risk for breast cancer and therefore should get mammograms. Of course, it makes perfect sense when you hear what the justification was. And she made that complaint, OCR investigated, went back to the CDC and said, we think that this policy is wrong, and they said, you're absolutely right. And so the guidelines were revised to allow mammograms to transgender women who have taken or are taking hormones. So that seems to be the new CDC protocol. That is what the Colorado Women's Wellness Connection Program has done. And that was the agreement that it reached with OCR. The next is Aetna, which denied transgender individual gender reassignment surgery on the basis that it was cosmetic surgery. And frankly, Aetna didn't even realize that that is how it had been terming its gender reassignment. And when it looked at the policy, they said, "You're right. It's not reassigned. It's not cosmetic surgery." And the policy was changed so that requests for gender reassignment are determined on the basis of medical necessity. The next example is a man who received transportation services in Georgia to his doctor's appointments from a private medical transportation service company, and he complained that multiple drivers harassed him because of his feminine gender expression. There was an agreement that that was inappropriate. The staff received training on how to avoid sex stereotyping and the uses of appropriate terminology. And the final example I've given you is out of the Brooklyn Hospital and the Boston Medical Center. Both centers received multiple complaints from transgendered individuals about procedures, including questioning in public waiting rooms regarding gender listed on their patient forms and not allowing transgender individuals to change their gender in their medical records without documentation of a completed gender reassignment surgery. Here I want to point out that the new rules do not require a transgender person to have gone through reassignment surgery in order to be able to identify themselves as transgender or to change the sex that they identify with on their birth certificate or in their medical records. So this was what was happening in both centers. Both were being a little insensitive by questioning someone who was transgender about the gender that they had at birth in a waiting room full of people, thereby allowing them so I'm sorry about that. I'm trying to do two things at one time, thereby causing them embarrassment. But the other was saying that we won't allow you to change your gender identity in your medical records until you've had reassignment surgery. That is simply now not accurate as to how the regulations read. All right, moving on. We're going to go to persons with limited English proficiency. The new rules require language assistance for persons with limited English proficiency, as Kim has been talking about. And the graphic there on the side shows that 82% of the population speaks English only, but another almost 18% speak another language and don't speak English. That's largely Spanish, but it covers a wide variety of languages. And for all of you that are involved in clinics or hospital systems, you know that the languages that are being covered or that are being spoken and that we need to be able to deal with are very large. All right. I'm locked out. Okay, let's talk about the two requirements under the LEP, or the Limited English Proficiency Discriminatory or Non-Discrimination Rules. The first relates to interpreters. Covered entities must offer a qualified interpreter to an individual with limited English proficiency when oral interpretation is a reasonable step to provide meaningful access. I want to point out that the Section 1557 of the ACA goes specifically to access to healthcare services. And very much like they did with sex discrimination, where they're trying to improve access to people who are pregnant or transgendered individuals to healthcare, the same thing is true with this limited English proficiency. So remembering that access is the ultimate goal, the standard is oral interpretation is necessary when it is a reasonable step to provide meaningful access. A qualified interpreter generally means one who, via a remote interpreting service or in person, so whether you're using a remote service or in person, adheres to generally accepted interpreter ethics principles, most importantly including client confidentiality. 2, has demonstrated proficiency in speaking and understanding both spoken English and the relevant spoken language. And 3, is able to interpret effectively, accurately, and impartially, both receptively and expressively, so both in understanding and expressing, to and from such language or languages and English using any necessary specialized vocabulary, terminology, or phraseology. This is important in the healthcare setting because it isn't enough just to be able to speak generally another language. It's also important to be able to speak in the medical terms that are necessary. So that the use of vocabulary, terminology, and phraseology is particularly important in the healthcare setting. The interpreter need not be licensed under state law, but must have the relevant proficiency, that's what we were talking about. Simply having above average familiarity with speaking or understanding the relevant foreign language does not necessarily qualify him or her as an interpreter. Again, they have to have the ability to interpret on the important topics that are covered in the healthcare setting. A covered entity that provides a qualified interpreter through video remote interpreting services must provide the following. So this is beyond, this is people who are, or entities that are using video remote interpreting. That video remote interpreting must be real-time, full motion video and audio over a dedicated high-speed, wide bandwidth video connection or wireless connection that delivers high-quality video images that do not produce lags, choppy, blurry, or grainy images, or irregular pauses in communication. Obviously here the important part is that there's meaningful communication in the healthcare setting. So they want it to be clear and able to communicate effectively. Number 2, a sharply delineated image that is large enough to display the interpreter's face and the participating individual's face regardless of the individual's body position. So the important part here is the face of both the interpreter and the individual. 3, a clear, audible transmission of voices. And 4, adequate training to users of the technology and other involved individuals so that they may quickly and efficiently set up and operate the video remote interpreting. Okay. In addition, in providing an interpreter, the covered entity may not do the following. So the last 2 slides were what was absolutely required, and here is what may not happen. Covered entities may not require an individual with limited proficiency to provide his or her own interpreter. I know that it's very tempting at times to say, is there anyone in your family who can come with you, or friends or the like, who can help with the interpretation? That is no longer permitted under the ACA rules. Number 2, you can't rely on an adult accompanying the individual with limited English proficiency to interpret or facilitate a communication except in an emergency involving an imminent threat to the safety or welfare of an individual or the public where there is no qualified interpreter for the individual with limited English proficiency immediately available. So emergency situations are exempt, or also exempt where the individual with limited English proficiency specifically requests that the accompanying adult interpret or facilitate communication. The accompanying adult agrees to provide such assistance, and reliance on that adult for such assistance is appropriate under the circumstances. So break that down just a little bit and think through how that might occur. It is so an adult accompanying an individual with limited English proficiency may interpret where the person with limited English proficiency wants them to, where they can provide that as service, and where reliance on that adult for such assistance is appropriate under the circumstances. There are times when it will not be appropriate. For instance, if a provider thinks that there is a domestic violence situation going on and the person with limited adult or limited proficiency has there the person who is the potential abuser, even though the patient may say, I want this person to do the interpretation, the provider may understand that in those circumstances that he or she may need to be asking questions that would be difficult in that situation. And in that case, that person wanting the accompanying adult to be the interpreter would not be appropriate. I hope that makes sense. 3, relying on a minor child to interpret or facilitate communication, except in an emergency involving imminent threat to the safety or welfare of the individual or the public where there is no qualified interpreter for the individual with limited proficiency, is immediately available. Again, we don't want to rely on children because the adult may feel uncomfortable using certain words or explaining certain situations that the child is being counted on to interpret. And so in that situation, we don't allow for kids to be the interpreter unless it's an emergency situation. And 4, a covered entity may not rely on staff other than a qualified bilingual or multilingual staff to communicate directly with individuals with limited English proficiency. So what is a qualified bilingual or multilingual staff? What does that mean? It means a member of the covered entity's workforce who is designated by the covered entity to provide oral language assistance as part of the individual's current assigned job responsibilities and who has demonstrated to the covered entity that he or she, number 1, is proficient in speaking and understanding both spoken English and at least one other spoken language, including any necessary specialized vocabulary, terminology, and phraseology, again, so that they have the appropriate vocabulary to cover the kinds of situations that are going to be dealt with in the healthcare setting. And 2, is able to effectively, accurately, and impartially communicate directly with individuals with limited English proficiency in their primary languages. Again, this need to be impartial, accurate, and effective in the communication is key. So those are the rules related to interpreters. Again, interpreters that are in person, by phone line, or by video. Now we're going to turn to the rules for translators. Covered entities must use a qualified translator when translating written content in paper or electronic form. Let me say that one more time. Covered entities must use a qualified translator when translating written content in paper or electronic form. A qualified translator is one who adheres to generally accepted translator ethics principles, including client confidentiality, that being very important. Number 2, has demonstrated proficiency in writing and understanding both written English and at least one other written non-English language. So not enough to be proficient in the spoken word. Here we're talking about proficient in the written word. And 3, is able to translate effectively, accurately, and impartially to and from such language or languages and English using any necessary specialized vocabulary, terminology, and phraseology. Okay? A qualified interpreter is not necessarily qualified as a translator, so interpreters aren't automatically capable of doing the translation requirements under the ACA's new rules. HHS cautions against the use of automatic translation technologies without the involvement of a qualified translator. So simply speaking into your phone and asking it to translate is not sufficient unless it's under the supervision of a qualified translator. And the regulations and accompanying commentary provide little guidance on when and which documents must be translated. That is, of course, the biggest unknown. Kim pointed out just a few moments ago that there are some areas of the guidance that are lacking, that we don't know much about. And here, again, the rules do not tell us exactly which documents need to be translated, although we can infer from the overall statements in the rules that key documents are going to need to be translated, and that interpreters are going to be required for any meaningful discussion with a healthcare provider that allows for access. Again, any kind of intake form, any kind of form that is an assessment that a physician or any other kind of medical practitioner is going to be relying on is typically one that should be translated. That's what I have on both discrimination based on limited English proficiency and sex. Teresa now is going to talk to you about disability. Thanks.
Hi there. As Pia said, my name is Teresa Locke, and I'm going to cover the last couple of sections with us on this. the first being the discrimination based on disabilities, and the last being enforcement. And then at the end, we'll talk about sort of summarizing what things that providers need to do in order to comply. So first, just as a recap of the ACA statute, this slide shows that disability is expressly called out as one of the non-discrimination areas. What is a definition of disability? Well, the ACA rules provide the definition that's on slide 44. Disability means, with respect to an individual, a physical or mental impairment that substantially limits one or more major life activities of the individual. This definition is very similar to the ADA that we're going to get to in just a minute, but that is the definition that's contained in the ACA. Or the rules to the ACA. And so not only that the individual can have a physical or mental impairment that substantially limits one or more major life activities, but it could also be a record of such impairment or being regarded as such an impairment. And it refers specifically to the ADA in this statute. And as a result of that, you'll find this in a few places in the rule where, because it's referring to the ADA or another statute that has some different terminology, they put phrases in to say if it says handicap, that also means disability, so that those two phrases are interchangeable. The next slide shows the ADA's definition of disability, and it is the same as the ACA's, with the exception of it defines what major life activities are. So specifically, major life activities include, but are not limited to, caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. Pretty darn broad as to what these major life activities are. And also, the statute goes on to say that a major life activity also includes the operation of a major bodily function, and again, gives a laundry list of what those functions might be. So there is a fairly large definition, broad definition of disability. The definition under the ADA shall be construed in favor of broad coverage to the maximum extent permitted. So if in doubt, you should assume that there is a disability. It only has to limit one major life activity, and an impairment that's episodic or in remission is still a disability if it would substantially eliminate a major life activity if it was active. Another thing that the statute points out is that you can't say someone is not disabled simply because they have some sort of a mitigating equipment. The only exception to that is eyeglasses and contact lenses, but otherwise, the fact that they have some mitigating measure doesn't make them not disabled. All right, so what must the covered entity do? So the first thing, there's a list of things, but the first thing and the broadest thing is take appropriate steps to ensure that communications with individuals with disabilities are as effective as communications with others in their healthcare programs and activities. And the rule then incorporates the standards found in another CFR site that we're going to talk about in just a minute that covers public entities. And so the definition, or this rule, goes on to say, so if you look at these other rules at 28 CFR 35.160 through .164, and you see the term public entity, you should just replace it with the term covered entity. The covered entity must also provide appropriate auxiliary aids and services, and that is defined, and I'll give you that definition in a minute, to persons with impaired sensory, manual, or speaking skills, and where necessary to afford such persons an equal opportunity to benefit from the services. So if they have trouble hearing or speaking or seeing, sensory, then you have to provide appropriate auxiliary aids. And you have to post, and Kim already talked about this earlier, but you have to post a notice of individuals' rights stating that the covered entity is going to provide those auxiliary services for them
free of charge and in a timely manner. So as I said a minute ago, the rule refers back to another CFR site, and so looking at what those CFR regulations say and remembering that they talk about public entities, and so I've sort of replaced the public entity with covered entity. A covered entity shall take appropriate steps to ensure that the communication is appropriate and effective, not only with patients that have disabilities, but with companions of patients that have disabilities. So if they bring their parent or their spouse and the spouse has a disability, then there is an obligation to provide for communication for that spouse. And here's the definition of a companion. If they are an appropriate person with whom the covered entity should communicate. So it's not just anybody that they bring with them, but if it's somebody, for example, if it's the parent that is deaf and they've brought their child in for treatment, then the services should be provided for a deaf or hard of hearing person. The covered entity, again, this is going back to these regulations that were incorporated into the ACA regulations, but the type of aid or service is going to vary depending on the type of communication, the nature, length, and complexity of the communication, and the context in which the communication is taking place. So it's a pretty fluid standard, and you're going to have to make some decisions about what's necessary, but covered entities should give primary consideration to the request of the individual with the disability. So finding out what they prefer and using that sort of a service is important. And it has to be, in order to be effective, of course, it has to be accessible, timely, and it has to protect the privacy and independence of the patient as well. So there's some guidance here from the Department of Justice. It's a little old, but it talks about communicating with people who are deaf in a hospital setting. And here are some things that the DOJ has said that interpreters or that the entity should consider when trying to determine what auxiliary aids to actually use. So the new rules, though, do provide for a laundry list of types of auxiliary aids that should be available for deaf or hard of hearing and for sight impaired. So for deaf or hard of hearing, there's a whole list, and I'm not going to read those to you. You can read those. But it's a pretty extensive list of the types of aids and services that could be available or could be used. And the important thing is the very last phrase, any sort of an effective method of making orally delivered information available to the individual. So there's a broad range of types of things, and again, knowing what the particular patient wants is the most, I think, important. For blind or low vision persons, they also give a laundry list of the types of things or the types of assistance, auxiliary aids and services that could be provided. And same standard at the end is sort of whatever's an effective method of making sure that they're receiving the same sort of communications as somebody without a disability. This is all is going to look familiar to you because it's the same definition that was in the LEP section that for qualified, I mean, it's a little bit different because actually the rule has two different definitions, but it's very similar. So a qualified interpreter for someone with disability as opposed to someone with limited English proficiency still has to adhere to generally accepted interpreter ethics principles, including confidentiality, and has to be able to interpret effectively, accurately, and impartially, both receptively and expressively. That is different from the LEP definition, using any necessary specialized vocabulary, terminology, and phraseology. That mirrors the other definition. So as an example, sign language interpreters are one type of a qualified interpreter, but you could also have an individual who spells in the characters of another alphabet or who represents or spells by using small numbers, a small number of hand shapes. Those are examples that were actually given in the rule. So just as it is with the LEP, the interpreter doesn't have to be licensed, but they must have the relevant proficiency.
Some other factors to consider when determining which type of aid that you'll be providing. There's a list here: effectiveness of method of communication with and without the proposed aid, the complexity of the communication. Some communications, when you're describing surgeries or something like that, may be much more complex than others and might require a different sort of auxiliary aid. The type of procedure, the size of the practice, the cost of alternatives, the number of patients who are going to require it. So if it's something that you have that's pretty widespread, then that's something to consider. Again, the patient's preference and the provider's risk tolerance. Going back to the standards, so I sort of went down this path of the auxiliary aids, but there are also other standards that were incorporated into the rule that the covered entity shall not require an individual with a disability to bring another individual to interpret for him and her. Just as Pia said with the LEP interpreters, you can't require a patient to bring a translator, a sign language person, or an assistant with them. If they bring someone with them, you can only rely on that adult accompanying the individual with a disability only if it's an emergency involving an imminent threat to the safety and there's no or welfare of the individual or the public, and there's no other interpreter available, or where the individual with the disability specifically requests that the adult interpret or facilitate their communication, that adult agrees, and that the reliance is appropriate under the circumstances. Exact same rule that Pia talked about in the LEP. And also the same rule is that the covered entity shall not rely on a minor child to interpret or facilitate the communication unless it's in an emergency and there's just no other option because there's no other interpreter available. I'm not going to go over all of this again because this is also the same as what was related to the limited English proficiency. It's interesting that the Federal Register and the new rule actually delineates all of these things in the context of limited English proficiency, but in the context of disability, they just refer you back to 28 CFR, but the exact same standards are found there. This slide talks about the standards related to TTY, text telephones, and if you're going to communicate with patients by a TTY, if you're going to communicate with patients by telephone, you have to have a TTY system as well. If you use an automated attendance system, such as voicemail or calling in and saying press 1 for this or press 2 for that, that also must provide effective real-time communication with individuals using auxiliary aids and services, including TTY and other types of FCC-approved telecommunication relay systems. So your phone system needs to be functional for people who are hard of hearing and use TTY services as well. And the last point on the telephone issue is that a covered entity shall respond to telephone calls from a telecommunications relay service in the same manner that it responds to other telephone calls. So you can't discriminate for people who are hard of hearing and using a TTY service. We talked a minute ago about this, but a covered entity shall ensure that interested persons, including persons that have limited or impaired vision or hearing, can obtain information as to the existence and location of these services. So you have to provide notice of that. You have to provide signage in all inaccessible entrances of the facility, telling users where they can go to get an accessible entrance. So not every entrance has to be accessible, but you have to have signage that directs them to the right place. And the international symbol for accessibility shall be used at each accessible entrance of a facility. Some sort of limits on things are that an entity doesn't have to take an action if it can demonstrate that it would result in a fundamental alteration in the nature of a service, program, or activity, or an undue financial or administrative burdens. But that, just be very, very cautious on that, because that is going to be very narrowly interpreted. The entity has the burden of proving that the compliance would result in this alteration or burden, and if you're successful in demonstrating that, you still have to take actions that would nevertheless ensure to the maximum extent possible that individuals with disabilities receive the benefits or services provided. So I don't want to lead you to believe that that's a big loophole that you can jump through. It's really not, but there is at least some language to allow some exceptions. So that's sort of talking about the hard of hearing and visually impaired. There's also sections in this new rule regarding facility accessibility standards. So the rule applies to a facility or a part of the facility in which health programs or activities are constructed. And this really mirrors the ADA significantly. So if you're already in compliance with the ADA, there's probably not much difference. But if you're not, then it's another layer of non-compliance that you should worry about. So it breaks down the rule based on when construction or alteration is being commenced. If it's starting after July 18 of 2016, which is the effective date basically of this rule, then if the construction is starting or alteration is commencing after that, then you must ensure that the buildings are compliant with the 2010 ADA standards for accessible design, which also incorporates some other standards. And you must comply with the requirements for a, quote, public building or facility as are defined in that 2010 standard. So the rule refers a lot to the 2010 standards. The exception to, if the facility was not originally covered by the 2010 standards prior to July 18, 2016, the facility can nevertheless comply with the standards if construction is commenced after January 18, 2018. So you get a little bit more time to be in compliance if you weren't originally covered by the 2010 standards. And there are some, you can depart from particular technical requirements if you use methods where substantially equivalent or greater access to the facility is provided. So that was sort of what happens, sort of breaking down when the time is occurring. The next section of the rule provides that if the construction is commenced on or after July 18, 2016, and it was done in conformance with the 1991 standards or the 2010 standards, it is deemed in compliance. So I think the thinking probably is that most everyone out there has already complied with either the 1991 or the 2010 standards, and so therefore that would equal compliance with the ACA rules. Compliance with the rules is also deemed if construction was done, if three things are met. One, the construction was done in conformance with the Uniform Federal Accessibility Standards. Construction was commenced before July 18, 2016, and the facility was not covered by either set of standards. So that's also compliance. All right, then this section now has to do with the technology accessibility standards. So we talked about with physical facility accessibility standards. This is about technology. So all programs and activities provided through electronic and information technologies have to be accessible to individuals with disability, again, with the two exceptions of if doing so would impose an undue financial or administrative burden or would result in a fundamental alteration in the nature of the program, then there can be an exception for having to comply. But even if you're able to meet that exception, you still have to provide information in a format other than electronic that ensures to the maximum extent possible that the individuals with disability receive the same benefits and services that people who can access technology are receiving. And this applies through to your websites as well, and making sure that they're compliant with the requirements of Title II of the ADA. So the last section of the disability rules that I want to talk about is reasonable modifications. So this is kind of maybe intuitive that you have to make changes, reasonable changes to your policies, practices, and procedures where necessary to provide for equal access unless you fit into the exceptions that we've talked about already. And reasonable modifications, that term is to be interpreted consistent with the requirements of the ADA, and I put the site there for that. So you have to keep your policies and practices and procedures in line with what the rule is requiring. So the last thing we're going to talk about is enforcement of the ACA rules. HHS, the Office of Civil Rights within HHS is responsible for accepting and investigating the complaints. They've been, as Kim said earlier, they've been receiving and investigating discrimination complaints since 2010 when the ACA went into effect, but have not had these regulations. And Pia's already talked to you about some of the investigations that they have done and kind of what the outcome of those were. Now that we have the regulations, I think we can safely assume that they're going to be implementing those and taking them very seriously. The ACA also allows for enforcement mechanisms that are provided for in the other statutes that, as Kim and Pia both said earlier, these are not replacing, the ACA's rules are not replacing the other statutes, they're just accompanying them or complementing them, and so all the other enforcement mechanisms are still out there as well. Enforcement mechanisms include requiring covered entities to keep records and submit compliance reports, conducting compliance reviews and investigations, providing technical assistance and guidance, and as Pia showed, you know, they really seem to be, at least up to now, trying to help people figure out how to comply and how to adapt to the requirements. But where noncompliance can't be corrected by informal means, then there are some available enforcement mechanisms that are much more stringent, and that includes suspending or terminating or refusing to grant or continue federal financial assistance. So there's some monetary issues there. They can refer it to the DOJ with a recommendation to bring proceedings, and any other means authorized by law. Moreover, individuals can file a complaint through the OCR, and they can bring a civil challenge to Section 1557 to a violation of it. And if they do bring a civil challenge, then compensatory damages are available in appropriate actions. Not sure exactly what appropriate administrative and judicial actions are, but I'm sure we're going to get a lot more guidance about that in the future. So that sort of covers the topics, and we want to just leave you with some action items. By July 18th, 3 months after the issuance of or 2 months, excuse me, 60 days after the issuance of the final rule, a covered entity with 15 or more employees has to appoint and train a compliance coordinator and has to draft and implement grievance procedures. Also, by July 18th, you have to review and, as necessary, update your policies and procedures for addressing discrimination situations. So, for example, to avoid sex discrimination, to provide the language assistance for limited English proficiency persons, to provide auxiliary services to persons with disabilities, and to assess your physical structures to make sure that they are accessible and you have the signage out that is necessary. Finally, by July 18th, you need to train your staff concerning the obligations and documents that are necessary. Then by October 16th, 90 days, I think, then you have to have the notices posted with the taglines, and Kim went over that in great detail about the languages, and you have to have them in physical public locations and on the website and in significant publications or communications, and we've provided the samples for that. You also, by October 16th, have to include a statement of non-discrimination and taglines in 2 languages in your small publications. And then as an ongoing thing, you need to watch for additional guidance and samples from HHS and OCR, and we will try our best to keep you updated on those things through client alerts. You need to, on an ongoing basis, you need to continue to train your new employees and periodically retrain your existing employees. Monitor your compliance, especially when there are changes in personnel or change in policies and practices, new significant publications or communications that you put out. Make sure that those are compliant. There are changes in the population around you, whether, you know, the language, the most common languages are changing. You need on an ongoing basis to respond promptly to complaints and to problems, and using the grievance procedures that you put in place. Educate your employees as appropriate if there is a problem, and document everything so that you can show later, if there is an investigation, what you've been doing to try to resolve the situation. As far as additional resources are concerned, we've attached here or put in some slides some screenshots and some other places that you could go to find additional information. The HHS website has some really good information on it, on the Section 1557 rules. Here is a screenshot of where you can go to get the various languages of for the taglines, etc. Also, we've got the things that we referred to in the slides, some other guidances and publications that could potentially be helpful to you. The OCR website has a lot of information on it, guidance and education, sample policies, etc. The ADA for disabilities has a lot of helpful information as well. And as we point out on the last line, there's a lot of stuff out there on the internet, but be careful of your source and make sure that you're looking at sources that are reliable. And I think the things that we have put forth in here are reliable. As always, we also can provide you resources. We do these webinars. They are available. Recordings of the past webinars are available if you go to our website. We have articles, forums, checklists. We try to put out client alerts. If you're not on the client alert list or email list, shoot us an email or something about that, and we'd be happy to add you. This is a screenshot of what our healthcare webpage looks like, where you can find all of these resources I've just talked about. And we have some upcoming webinars that I just want to promote to you that should be really, really helpful in the rest of June and July. You can see them there, and there are publications. You can also email any of us, as Kim said earlier, with any questions that you have. I do see that there are several questions in the Q&A section. We're way over our time, so we won't take the time to answer those right now, but we will get those printed out, and we can answer those questions individually. So thank you so much for participating with us today, and we look forward to seeing you next time.